I'm Steve Margaret. She came with us yesterday at the art museum.
Oh, yeah.
Is this your first Cali too?
Yeah.
Oh, congratulations. We got pictures. We got pictures of Margaret and Emily at the art museum.
When did you guys go to?
Last night.
How far away?
A couple stops, not too bad.
Yeah,
It's really good. It's a good mix of like contemporary art, folk art.
All right, well, thanks so much for coming, everyone. We'll probably still have a few people trickling in. I think it's 12 o'clock now, so I'll go ahead and get started. So, again, thanks so much for coming. My name is Jesse Bowman. I'm the Electronic Research, Technology, and Instructional Services Librarian at Northwestern in Chicago. Appreciate you making it. I know this is a tough time slot between other good sessions going on. I know we're all a little conferenced out, so I appreciate you coming for my session. So just a little bit about why I wanted to develop this presentation. So I'd like to get some feedback from you guys throughout the presentation, but essentially the last couple times I've taught advanced legal research, I've tried to incorporate things like Ravel and Casetext, but typically what I've done is maybe just had a session towards the end of the semester where I talk a little bit about these new tools, but I've honestly not felt like they've really gotten the attention they deserve. Typically by the end of the semester, people are pretty worn out, have a lot of questions about their project, and I feel like in the end, I really didn't do a very good job of covering that, especially given how much publicity these different systems are getting. So I put a couple screenshots on here just of various articles. You may have seen some of these, but just talking about crowdsourcing, visual learning. Ravel got a pretty good write-up in the ABA Journal. You may have seen that Lex Machina won the AALL Product of the Year award, and they just got bought by Lexis recently. So, basically the idea was I wasn't giving these enough attention, and I honestly thought by presenting something at Cali, this would really force me to think about how I want to bring these products into my class. Admittedly, a lot of this is perspective. I'm hoping to really bring this in a lot in the fall. So unfortunately, at this point, I don't have necessarily a resounding success story about how the students love this and it was perfect, but this is what I'm hoping to do. So I wanted to get some feedback from you all and thought we could just kind of talk about it. So just an outline of what I'm hoping to do. So I want to spend just a little bit of time talking about these new legal research platforms. I know probably a good number of us have played around with them just a little bit, but if not, that's okay, or if it's been a while, that's fine too. I'm going to spend just a couple minutes kind of breezing through each one. I want to talk a little bit about what we've seen so far in terms of how they've been adopted in law practice and in academia. As we'll see, there's not necessarily been a lot written up about how they've been implemented in academia, but there is one good law review article out there that I can recommend to you guys. Some of my thoughts on why I think these tools are worth incorporating. And then finally, I've tried to come up with like 5 concrete ways that I think we could bring them into our instruction. And I should say, feel free at any time to interrupt me or interject or ask questions. I'd like this to very much be a discussion and informal. Okay, so the new legal research platforms. So I listed out a couple of them here. So we have Ravel, Casetext, Lex Machina. Fastcase has been around for a little bit longer, but they have an interactive case law timeline feature, which admittedly I haven't used a lot in my instruction, but I think is really neat, and it aligns with essentially what Ravel's trying to do with the visual learning. So I wanted to bring that to your attention, and I think that's something worth teaching in class as well. These aren't all the platforms by any means. You have PacerPro, for example, is another one of these kind of new legal tech research platforms, but I thought for our purposes this would give us enough to work with. Okay, so I'm going to demo each of these systems a bit, but I wanted to give just a little introduction. So the first one I wanted to talk about was Ravel. It's available at ravellaw.com. The basic idea is that it's bringing data visualization and analytics into legal research. So you kind of compare the traditional Westlaw, Lexis, or Bloomberg search results versus you get this cool visual graphical representation on Ravel. The idea is it's kind of for different learning styles. I think it's a big departure from what we're used to, but it's a neat take on it. Also, they have a case analytics platform where you can look at an opinion and really see what kind of influence the opinion's had over time. Essentially, you can see, maybe it used to be cited a lot, but that's fallen off recently, or in recent years it's gained a lot of popularity. One thing I did want to point out is students have free access to the advanced plan on Ravel. They just need a law school email and they can get access to the advanced plan, which isn't necessarily the most souped up option, but for our purposes it has a lot of good material that they can work with, and it's free. I also want to talk a bit about the Judge Analytics platform. Now, if you haven't had a chance to play with this, this is a really cool new tool that Ravel offers. I did want to point out that it's surprisingly affordable for academics. So we just got it at Northwestern, and from everything I've gathered, it's anywhere from $3,000 to $5,000 per year. So not that that's nothing by any means, but I think for what it can do, I personally was shocked that it wasn't way more expensive. So let me go on and just show you a little bit about Ravel. So we'll go to ravellaw.com. It recognizes me. Now, just to show you here, if we go to the plans, so anyone can get open access. You don't have to sign in for that. And essentially with open access, you can run a search and you get the visual representation, but you don't get any of the case analytics or any of the judge analytics. What I'm relying on is this advanced plan, and this is what all students and all faculty can have and librarians can have access to. It doesn't include the judge analytics. Like I said, that's a separate add-on. But like I said, for that $3,000 to $5,000 range, you can get the advanced plan plus all the judge analytics. So let me just show you here what we're doing. So let's just try, for example, we can put on a court filter. So let's select Georgia. And it has the Georgia Supreme Court and Georgia Court of Appeals. Let's try employment discrimination. Okay. So, as you can see, compared to what you typically get with search results in Westlaw, Lexis, or Bloomberg, this is quite a bit different. Basically, the idea is that each one of these circles represents a case. The larger the circle is, the more citations it has, the more later citations it has. We can get a little breakdown here if we click this legend icon, and it will show us here. It gives us a breakdown. So the larger the circle, the size. In this case, we're working with just state courts, so all the circles are the same color. But if we were to, for example, have done an 11th Circuit search, we would see some different color circles for like the 11th Circuit versus the Supreme Court. Also, if you highlight a particular circle, you can see these lines pointing back at it. So this is a timeline down on the bottom. So anything later pointing back to our case is a later citation. But if we were to hover over this one, for example, we can see earlier cases that our case has cited. So you can sort them by either relevance, which is what we've done. You can also do court separated. So in this case, it'll put, well, these look to be mostly, well, I guess honestly it works a little bit better on the federal side, but it'll break them apart by like Supreme Court, 11th Circuit Court of Appeals, or District Court. So we can also then add in, if we were to add age in, we can see it'll change our results. Over on the right, it lists what it thinks are the 75 most relevant cases. Now, when we go into an opinion, so as we'll see up here on the top left hand, this is what I was talking about, so you can trace how often this case has been cited over time. So I guess not entirely surprisingly, this was a case from 1987. So we can see here, it might be a little bit tough to see, but each one of these bar graphs is a year, and the citations really peaked in the early 90s, and they've kind of trailed off since. You can also go through and look through each page of the opinion and see how often that particular page has been cited. So I think it's really helpful to see, maybe this case has been cited 100 times, but 95 of them are for this one provision from this page. So it really helps you track, how a case has been used. Now we'll dive more into the Judge Analytics platform later, but just to give you an idea, if we were to do here, let's enter in Judge Posner. Essentially, you can get a breakdown to see, in this case for Judge Posner, what cases he cited the most, what jurisdictions he cited the most, and also what judges he cited the most. On the flip side, we can go in and look at his opinions, and we can isolate particular opinions on certain topics. So if we wanted to see, for example, just the employment discrimination opinions from Judge Posner, we can go in and isolate those. So I think this has some really cool potential for our legal research class, and I'm going to dive more into it later, but I just wanted to give you a basic overview. Okay. Yeah, I think we're getting a little bit cut off there. So Casetext, some of you guys might have gone to Pablo's presentation on the first day, but Casetext is essentially, I think it's kind of referred to as like the Wikipedia for legal research. So what they've done is they have case law, statutes, and regulations on there. The case law, though, has crowdsource annotations, so people can go in and add little notes into the case opinions and say, oh, here's a blog post that talked about this particular case. Just like Ravel, it lets you see which portions of a case have been cited the most, so you can go through and see, this particular provision's been cited 47 times. What's neat about it also is it is a publishing platform, so I'll go on and show you, but essentially anyone, which is kind of a mixed bag, I think, and really anyone can go in, put these annotations on cases, but also academics and attorneys, if they're approved by Casetext, can upload articles. A lot of times they just push things that have been published, like in their law firm newsletter, onto Casetext, and when you run a search, it comes up in the results. Casetext is freely available. I did want to also mention that they have a crowdsourced citator they're working on building, and that's particularly what Pablo was talking about. It's not done yet, but the idea is going to be that eventually it's going to end up hopefully rivaling KeyCite or Shepard's or BCite. So we'll go to Casetext here. So one thing that's neat, so Casetext has these different research communities. So I follow, I guess not surprisingly, the legal research community, but they have a bunch of different communities that you can join on here. So for example, if you're interested in civil rights law, employment and labor law, you can follow it, and then when you log into Casetext, you'll get the most recent publications on that topic. Something that's neat about it is if you go in, read an item you like, it has this crowdsourced, it's kind of like a gamification system where you can upvote things you like. So ideally, the better articles will come to the top of the list. Okay, so let's run our same search here. We'll try employment discrimination. And let's go ahead this time and pick 11th Circuit and see what we get. So you see here we get our results ranked by relevancy. This particular opinion, we can go through, and over on our left-hand side it has this heat map, and essentially this lets us know, again, what pages have been cited the most. The darker the blue, the more it's been cited. So, if we go to this case, we could see it looks like page 1024 has been cited the most. So we could go in and It looks like it's about the applicable legal framework, so it makes sense. This is probably a part of the case that people would be most likely to pull out. And you can also click these little clouds here, and it will show you the particular case that cited that provision. Now, this one doesn't have, let me clear this here. This particular case doesn't have any insights attached to it, but we can see up here it lists insights. So this would be if someone has gone on and said, put a blog posting, put a newsletter publication that cites this particular case. This is where you could find the link up under this insights section. And we'll talk a little bit more about that later. Okay. Okay, so Lex Machina is the third one. So Lex Machina is really an amazing litigation analytics platform. At this point, it just covers IP and antitrust cases. There's a lot of talk that they're going to expand to more than that, especially now that Lexis has bought them. So it's just on the federal side. It's just IP and antitrust. So the application's somewhat limited for our classes in that we'd have to really craft an IP example or an antitrust example. One thing I learned though, it's available to law faculty and students that are directly engaged in research on or study of IP law and policy. So it's freely available. There's a few neat motion analytics components that we don't have access to, but essentially all our faculty and students and librarians can get access to Lex Machina. The one catch is you have to watch it's an hour-long public interest demo, but it's actually a really interesting demo. They do them a couple times a month, and it really kind of just shows you the in and outs of the platform. And I'll also post these slides for you guys. I didn't get a chance to do it yet, but so you'll have all the links and everything. But I found them, it's real easy. Watch the webinar, you get access. Let me show you again kind of how this works. So this is what Lex Machina looks like. We can see here that it goes back to the year 2000 up through 2016. And we'll dive more in later, but if we were to, for example, click cases here, and let's say we wanted to look at copyright cases before the Northern District of Georgia. So what we can do is we can use our filters. Let's select copyright. And then for courts, we'll select Northern District of Georgia. Okay, and we'll apply our filters. So we get a breakdown here. We can track the filings per year in the Northern District. We can also get a breakdown of the different judges, what percentage of the copyright cases they've heard. If we go in and look at timing, we can get medians, averages, a whole range of how long the different actions typically take in copyright cases before the court. So we can see, for example, that for the granting of a permanent injunction, the median time is 226 days. Only 10 cases have gone to trial, but we can see how long those have gone. Cases that are terminated, typically 205 days. Also, we can go in and look at the case resolution, so we can see, of all these copyright cases before the Northern District of Georgia, 7% resulted in a claimant win, and even within that, we can see 2% of those were default judgment, 3% were consent judgment. Tough jurisdiction for defendants, only 1% have won. 7% have had some sort of procedural resolution. About a quarter of them have been settled. And then the no case resolution, according to Lex Machina, is like if the case is still open. I'm a little confused by that because it seems to me that 61% of them wouldn't still be open. But basically, you can go in and just see how, you can get a lot of averages and a lot of good, I guess, kind of strategy for your case. Okay, and finally, I wanted to just show you on Fastcase here. So if we run a search, we just searched Georgia state courts for defamation. And if we go to our interactive timeline, so it's similar to Ravel, and admittedly, I hadn't played around with this feature a lot until I started preparing this presentation, but what we're getting here is, so the yellow circles are cases in our results. The larger the surrounding gray circle is, that's the more cases that have cited our particular case we're looking at. And for the orange circles, it calls those foresight results. So those are cases that aren't technically in our search results, but Fastcase thinks that we should know about them. And it makes sense because we searched for defamation. We limited our results to Georgia state courts, so we're getting mostly, obviously Georgia opinions. But then the largest foresight result is New York Times versus Sullivan, the U.S. Supreme Court case. So I like that foresight feature, and I think this has some potential, especially for visual learners, kind of bringing it in with Ravel and then comparing it to Westlaw, Lexis, and Bloomberg. Okay, great. And I did want to mention Fastcase. So I was talking about the interactive timeline feature, and it's really affordable for academics. So through Nelco, it's $1,000 per year for a subscription. So again, not that $1,000 is nothing. And, I'm glad it's not my money, but in terms of library budgets, I think for what you get, it's a pretty good price.
One thing you need to know if you want to use Fastcase though for assignments, that's a single subscription. So one student's results are going to show up to the next student who logs into your access.
In the history section you're talking about?
Yeah, exactly.
Yeah.
So it's shared. There's no private access for individual students with that.
So, go ahead.
We get ours though through the State Bar Association. So students are all student members, which they get for free, and part of that is they get the Fastcase membership, so they have their own logins. So check into your local bar on that.
And that's a great thanks, guys. Then so it might work in the academic setting. It might work better maybe in terms of like just the instructor demonstrates it as opposed to having every student. And I'm going to mention that later too. But I think at this point something like 28 state bars have Fastcase agreements, and a lot of voluntary bar associations do as well. And in terms of attorneys out in private practice, the yearly subscriptions are pretty affordable as well, in terms of a low-cost option. And I'll show that later here. Okay, so just talking a little bit about how these have been adopted in practice and in the academic setting. So, there's not a whole lot out there in terms of white papers or statistics, but through all the sites you can get an idea just generally how these have been adopted. So Daniel Lewis is the CEO of Ravel. He was quoted, this was at the end of last year, in an article here that the vast majority of firms in the AmLaw 100 have attorneys who have accounts on Ravel, and that they have specific firm-wide engagements with a number of them. Casetext, so we have thousands of lawyers and law firms, including a majority of the AmLaw 200. And you can see that a lot, and we'll look through those research communities, and you can see authors, have their own name, and then they have their firm affiliation. And you can go in and see a lot of the major law firms have contributions on Casetext. So Lex Machina, kind of just personally, anecdotally, I know a librarian that works out in Silicon Valley for a law firm. She mentions, her attorneys love Lex Machina. You get some quotes here from, in this case, in the press release talking about Lexis acquiring them, 45 of the top 100 IP law firms, and you see a lot of the multinational companies, Nike, Google, IBM, eBay. Again, Lex Machina is going to be the most specific for IP and antitrust. If your students don't do a lot of that work, or if you aren't necessarily in crafting examples in those areas, Lex Machina might not be the best one to use, but for that particular practice area, it's great. And this is what we were talking about earlier, that 28 state bar associations, and dozens of voluntary bar associations have Fastcase as a free benefit to members. Okay, so that's obviously all the kind of commercial promotion. There is one really excellent law review article, and you guys may have come across this. It came out, I think, about a year ago. It was in the Rutgers Computer and Technology Law Journal. Some of you guys might know Ingrid Mattson out at Ohio State. She partnered with one of their legal writing professors, and they did a Casetext and Ravel module in the legal writing professor's class. So it really had three components. They began by just surveying their students to see, if you guys even heard of Ravel or Casetext. Then Ingrid came in and did a demo of Ravel and Casetext in the class, and then they did a follow-up survey. So just a little bit about how they structured this. So they purposely waited until the middle of the semester to do this module. Students were writing a brief, and by this point in the semester, they had done a lot of their research on Westlaw and Lexis, so they really knew, what are the major cases in the area. So I think that was important because it really allowed them to kind of compare what they found on Ravel and Casetext versus what they'd found on the traditional systems. An important point, so the instructors went in beforehand and made sure that the cases they needed were on Ravel, were on Casetext. They actually went in and added some annotations in Casetext just to kind of highlight that feature. So the in-class exercise was they had students brainstorm search terms, and then they had them all run searches on Ravel and Casetext and kind of compare the results to what they found on Westlaw and Lexis. One point, and I think this led to an interesting discussion, is they had some students log into Ravel and run the search. Some just used that open plan, and they kind of compared the search results and showed, well, if you're not logged in, if you don't have an account, the results are much less than what you get if you're signed in. And it also led to a discussion just essentially how these different systems get their case law. At this particular time, I know that the coverage of unpublished opinions wasn't as great on Ravel and Casetext as it is now. So it led to a lot of discussion of, well, you get those unpublished opinions on Westlaw and Lexis that you don't get on Ravel and case law. That's not as much the case anymore, but I think that kind of highlighted, well, maybe what you get with the pay systems versus the free ones. So the feedback they got, the majority of the students liked Ravel and Casetext and said they'd use them again. But they thought Westlaw and Lexis were easier to use. The students did have some reservations about reliability and completeness of Ravel and Casetext, and I think the authors thought that was a good thing because that was a teaching point in itself that you have to consider with some of these new sources, well, what's the coverage? Is it authoritative? So it led to a lot of that discussion. And generally, students just appreciated being exposed to these new systems. Okay, so why should we go ahead and teach these systems? Well, if you all have, yeah.
The larger article you were talking about, could you get the site, could you show the citation for that again?
Absolutely. So it's 41 Rutgers Computer and Technology Law Journal, page 31.
Thank you very much.
Yeah, no problem. And I'll post these slides for you guys too. Okay. So some of the reasons I think these are worth teaching. First of all, the cost considerations. So like I mentioned with Ravel, the open plan, now you don't get, again, any of the case analytics or the judge analytics, but just the open plan where you can run the search, that's completely free for anyone. And I think for new attorneys, if they're going to be having clients come in that maybe have done some research on their own, or maybe the attorneys are going to open their own practice, this is a good tool to know about as kind of an alternative to the more established platforms. Again, Casetext is free like we talked about, and this just shows the pricing for Fastcase. So like we've talked about, 28 different state bars have the agreement where members get it for free. But even if you work in a state that doesn't have that agreement, but you really like Fastcase, their most souped up premium plan is $995 per year. So I think it's reasonable to think even if students go to a state that doesn't have Fastcase, if they really like it, this might be a cheaper alternative to Westlaw or Lexis or Bloomberg. Yes?
Can you characterize them as an alternative would you say that any one of these platforms or any combination of these platforms would be a replacement or a competitor to West, Lexis, or Bloomberg?
You know, at this point, I don't think so, and I don't think they're necessarily. I mean, on the one hand, you have Lex Machina, which is more of the analytics and the strategy. I think they're aiming, like Casetext with their citator is aiming to hopefully make that something that you could use instead of Keysight or Shepard's or B-Site. But the most I've talked to them at this point is they're really thinking it would probably supplement what you would do. So for example, maybe you'd use Ravel to find a really relevant case, and then you'd plug that into Westlaw to use the topics and key numbers, or plug it into Shepard's. Yeah.
Well, I mean, from a purely academic standpoint, one of the hurdles I've had with this is that if you want to cite one of the cases that will actually Ravel, or they want a Lexis or a Westlaw site. While I assume that you could construct a resolver to port over, or you can get to a permanent site. Is there how close to being like a DOI or a permanent URL are the cases in each of these platforms? Because journals, are innately conservative and don't want to do anything that might not be safe.
That's a great point, Dan, and I honestly, I don't know the answer to that, but that would be something to consider. You're right, because with new platforms, I think part of what we're trying to do is, maybe show students this new way of thinking about things, this new way of doing research, when in reality, as much as stuff is changing, we don't know if these will be around in 2 or 3 years.
Well, the other thing is just, I don't want to have them, encourage them to, go do your research in Ravel, and then you have to find the same case in Westlaw.
Right. Because I think as an academic exercise, maybe, but in practice, it's not efficient. Emily.
Although I do think that in some firms they're encouraging, especially getting attorneys to maybe do their initial research in one of these and then go back to myself for the cost savings. So talking to them about what each search costs and why you might use this, just to make sure you're headed in the right direction and do your initial, I'm thinking about this kind of research.
You could just give Westlaw a list of citations and have it pull the cases. It does do that. Nobody actually uses that function, but it will do it.
But being aware of what the costs are is something, and I think we brought in a firm librarian who could actually say, okay, how did you do your research? Let me tell you what the cost would be for that versus if you use this tool to make sure you were headed in the right direction once you were sure, then you use this to get the full results.
Yeah, and that's the few firm librarians I've talked to that work for firms that still bill quite a bit back. I've heard them say they really encourage their summer associates to not kind of just do fishing expeditions on Westlaw or Lexis, but to go on to if nothing else, Google Scholar or Ravel. Try and find a couple good cases and then take them on. But yeah, those are great. Those are great points. And the permanency issue it's something to think about, because I think we don't really know necessarily if these companies will survive.
I wonder for that, maybe for summer associate, but in a big firm where everything is billable in 7.5-minute sections or whatever, I'm wondering if a firm librarian would be okay with the attorneys doing that and then redoing the research on West and Lexis. My other thought would be, our school, we put out a lot of solos and people into smaller firms. And if for the free things, that might be a good supplement, but money is a real issue for a lot of these smaller groups. So if you're, like you said, $3,000 to $5,000 that's the academic price.
Right.
But if you're scraping by to make your Westlaw payment, something on the smaller law front,
No, and admittedly, it's been a change for me in teaching that before I came to Northwestern, I worked for more of a regional school, and obviously it was a lot more students that were going to open their own practice or go to a small firm, and it's been a different kind of experience teaching these students that are all going to these firms that have these huge research departments and libraries, and I agree. It's I think. My ultimate hope with this would be, maybe they would get a couple ideas. They wouldn't necessarily be able to use all these tools on their own, but maybe just even exposing them to the idea of, analytics and search visualization, whereas even if they necessarily couldn't afford the particular products at the moment, at least they'd be aware that they're out there. But I think that's a great point. It's a great point. Talking a little bit about also the AA, principles and standards for legal research competency, I think 2, 3, and 4 kind of tie into what we're talking about. So successful legal researcher gathers information through effective and efficient research strategies. A successful legal researcher critically evaluates information. And in particular, a successful legal researcher applies information effectively to resolve a specific issue or need. And I think, especially with the analytics, you could kind of tie that in that, if you have information on, what cases a judge likes to rely on, what's the likelihood that this is going to be successful or is going to settle. I mean, I think that does kind of fall within that idea of taking information you have to be a successful researcher. Okay, so we also have the requirement of technology competency. So there's been the ABA Comment 8 to Model Rule 1.1 on technology competence. I think just in March, I think it was North Dakota adopted this. So now there's 21 states that have it. I always tell my students that in Illinois, we have this. In Indiana, you don't. So if you're going to go to Indianapolis, technically you don't have to be technology competent yet. But I think more and more states are adopting this comment, requiring some baseline level of technology competence. Now, there haven't been any actual ethics opinions yet coming out about this where some attorney has gotten in trouble for not being technology competent. Certainly nothing out there about they didn't know how to use Ravel or Casetext, so they had an ethics violation. But I think this kind of comes in the idea of knowing the benefits and risks of relevant technology. If there's these new legal research platforms out there relying on big data, this is something I think is good for them to know about at least.
I've heard a lot of talk about that with relation to the cloud and attorneys who save their information in the cloud.
Exactly.
And exactly how secure is the cloud? If it's behind one password, or is it a firewall, or is it whatever?
Yeah.
And that's becoming more and more common because you don't want to pay for storage space, electronic or physical.
Exactly. Well, that is something. If you Google it, it's the ABA Legal Technology Resource Center has a whole page on the different state ethics opinions on the cloud and things like that and metadata. From what I've seen in terms of the cloud, all the jurisdictions have said it's okay, but there's definitely things you need to consider about physical security, encryption, geo-redundancy, all that stuff.
This is an oversimplification, of course, but generally the consensus seems to be like if it's behind a password, it's good enough. And
yeah,
as someone who deals with family members who constantly get their emails hijacked, that makes me a little nervous.
Well, absolutely, and I think I've gone to the ABA Tech Show a couple times and hearing no matter how many ethics opinions come out and say something like that's fine. There's a substantial number of attorneys that say I'm never going to put client information out in some server somewhere. They want to keep it all in house. So
if they're hacking the DoD, they're probably going to be able to hack you too. So.
Exactly. Yeah.
I would be a little careful of you don't have to be technology competent because a state doesn't have something that specifically says technology competence.
Right.
Georgia does not, but I can tell you that counsel for the Georgia Bar believes that the standard you need to be competent to practice law covers technology competence.
Yeah.
So just because you don't have a specific rule for it doesn't mean that you won't get burned. Do something you shouldn't. So.
I just listened to a podcast recently where that was the discussion where, in a way now there's this actual express requirement, but has there always kind of been a, and I think that raises a great point, and I think, in a way it's almost been kind of a badge of honor historically for attorneys that, we're not science and math people, we don't understand technology, but I think that can't be the case anymore.
Well, and I would challenge that you're using a tool and you have to understand how the tool works. And
Right.
just as you would not hopefully
leave your paper client file sitting in a public space, you should not be doing that just because it's electronic. So,
All of this is part of the evolution of the profession. I mean, years ago, attorneys advertising. Attorneys don't advertising. I mean, it's so base, it's so dirty. Now turn on the TV and find a station that doesn't have an attorney advertisement. So things evolve, and as things get more digital, we're going to have to evolve our understanding of what it is to be legally competent, with or without a standard.
Absolutely. Yeah.
Right now, though, there's a degree, it's like, I'm not gonna expect attorneys or even my students to go past that legal technology audit. It's like, I've looked at that, it's like, they're gonna fail. Innately gonna fail. So what is it to be actually competent? It, I think, varies according to who you're asking, especially when it comes to the firm, because like the firm's gonna just mandate certain things that you're gonna have to be able to do. And I think a lot of that's gonna come out in the wash. You were talking about the legal ethics opinions. Teaching those I've had to do for CLEs is like, they're way behind.
Yeah.
They just don't, it's really a case-by-case basis, so I don't know if there's any way to predict what somebody's gonna determine as competent.
Right.
Well, the base level of competence changes, and we've seen a lot of presentations about that just here at this conference, about digital natives versus digital immigrants, I think was one of them. And as people grow up in a more technological world, I think what might have served as competent for now in 5 years will sound ridiculous.
Well, yeah, that's actually one of my pet peeves, is that you have all these programs like so-and-so the digital age. Like, let's just click now.
We're dealing with now.
Yeah, so it's like, I don't want law library in the digital age. That's just now, because like, you're not offering me Bronze Age. So, this kind of competence is, I agree, it's just being generally competent is going to cover all of this. And it's going to come out in the wash once you get challenged, or if there's an ethics violation filed against you. That's going to, I think you were talking about the raises, all those, that's going to happen. It's just going to happen.
Yeah.
I will say I'm actually on the technology committee for the Indiana State Bar Association.
Yeah.
So no, they're not technologically competent attorneys. And we actually adopt, I think, the same general idea that Georgia does.
Right.
That competence is competence. Now, interestingly, we are discussing right now in our committee whether we need to propose adopting the ABA standard. But I think the other question that we're grappling with right now is what is technological competence. So it is an interesting discussion right now in the bar associations.
It is, and I think, like you get a lot of times, the ethics opinions are like a snapshot in time, and then you think how much technology is advancing. I think also, I've always kind of tried to tell my students, you don't necessarily, it's kind of like everything else with law school, issue spotting. Maybe you don't necessarily have to be a whiz at the technology, but you need to at least kind of understand what some of the issues are, what I need to go ask IT for help with. That's, I think, maybe another way to frame it.
There is a large distance between people, even in small firms, where you'll have the partner who needs the new associate to set up his BlackBerry ringtone, and the person who's basically a lawyer/IT guy who's fixing all the computers. So it's a large range just now, and I think, as I kind of mentioned before, people retire. From the profession, and people who are exposed to these digital things. I mean, everyone's probably seen the YouTube video of the baby, poking the magazine, trying to swipe the screen. It's a brand new world.
It is.
Every generation, every half generation, whatever it is.
And back to the confidence thing, and with vis-a-vis technology for lawyers, I mean, it's doing your due diligence.
Right.
More than anything else. It's knowing what you don't know, when you need an expert, and knowing how to vet an expert.
Right.
It can be that simple,
Yeah.
quite honestly. You don't yourself have to be an expert, but you need to know how to hire one.
Know how to find
You
it.
need one.
Yeah. Great. Well, thanks for all the feedback. one other kind of point about this, kind of going back to why it might be helpful to teach these systems. So different learning styles. So this is just a screenshot here. Some of you guys may have seen this, but Sarah Glassmeyer did this mind map of access to justice. And I think just kind of comparing this to here, we have a law review article kind of talking about the ins and outs of access to justice. And I think, for me, I've probably always been someone who I would learn by reading that law review article rather than reading this mind map. But I think there are people that would get the idea better maybe by looking at the mind map. And I think it's similar to, if you think of like an outline in law school, reading about the different elements of negligence. In my outline, I had it written out in a paragraph, whereas someone might do a flow chart, where they have negligence and then the different elements kind of extending out from that. And I think different learning styles, these platforms will accommodate them as well. So you look at, here's what we have our results for defamation on Westlaw, just kind of your traditional list. Here's what they look like on Ravel. There's going to be a lot of overlap between those cases, between the results, but some learners might get more out of this second slide than out of the traditional list. Okay, and then finally, this was just a quote I took about Lex Machina, but the idea of experiential education, practice-ready grads. In this case, it's talking about an IP case and a particular judge is tough on a certain type of motion. So I think, using these tools, essentially it might get our grads more in the mindset of, I've kind of always approached legal research like it occurs in this vacuum and, you have all these cases, but in reality you might be appearing before a particular judge that has a tendency to rule this one way or likes this one case that says what the standard for summary judgment is. So I think this brings in a little bit of that idea as well. Okay, so real quick, if you wouldn't mind going on to, if you have your laptop or phone handy, if not, that's okay. If you could go to this menti.com and enter this code. I have a couple questions I wanted to just pose. Okay. Oh, I'm sorry. It's let's see here. Okay. Did everybody get the code? So far, I'll bring up our results. Okay, so it looks like thus far, Fastcase has been the most of these platforms, followed by Ravel and Casetext, and then Lex Machina a little bit. So I think that's about what we'd expect, combining the ease of accessing them plus Lex Machina is the most subject specific. This. We're running a little short on time. So does anybody have like a story about how they've incorporated them? I'm guessing, maybe just generally some of the search visualization.
We do a presentation for what we call free and low cost legal research.
Okay.
It's not something that we generally do in the advanced legal research class, but it would be more kind of a side presentation we would do if a faculty member asked for it in one of their classes.
Okay.
I'm reluctant to do the presentation personally.
Yeah.
Simply because I haven't found any combination of free and low cost resources that I would be comfortable telling somebody who's a practicing attorney, you're cool if you use this.
Right.
Whereas if you've got Westlaw or Lexis or Bloomberg for that matter, I feel that gives you all you need because it's got the citator,
yeah.
It's got more comprehensive access, it's better organized generally. And that's just a function of money. I mean, if you're dealing with Ameriprise or you're dealing with your individual broker on the corner, it's
makes a difference.
you can even take the metaphor to lawyers. if you're dealing with the big Manhattan firm that's got 10,000 lawyers, and you're the solo practitioner who's got to take that on. I mean, it makes for a great movie when you win, but for the most part, they're just going to drop so much paperwork on you. I mean, it's not a fair fight, I'll say that. And to tell somebody that they're okay just with that makes me a little nervous from an education perspective.
I think it highlights that issue we've talked about where Westlaw, Lexis, and Bloomberg, some combination of those can be comprehensive, where I think at this point, one of these other services, it would be tough to really thoroughly research using just the free or low cost and not then bringing in, at a minimum, Shepard's or Keysight from one of the commercial providers.
They say, well, what should we do if we don't have access? We say, well, we have, Westlaw Public Access here. You're welcome as an alum to come back.
Right.
And that's the best suggestion. Or go to the courts. They have Lexis Public Access. And that's the best suggestion I can give them for free and low-cost research.
Yeah.
If I'm being totally honest.
Absolutely. It's a great point. Well, I'll include these results with the materials, guys. Okay, so we're running a little bit short on time. We only have about 10 minutes left, so I was going to work through all 5 of these. I'm going to just pick a couple particular ones, but you'll have it in the materials, and I'm curious to hear what you think. So my first idea was, and we can just talk about this briefly, but running a search on Westlaw or Lexis Advance, running the same search on Fastcase, and running the same search on Ravel, kind of comparing the results, what each system determines as the most relevant cases, then bringing in some more specific search strategies, for example, using Boolean connectors, seeing if you can find something in the same sentence as something else. In some of the examples I've done, I've found that a lot of times what will happen is the different systems will find different cases to be more relevant than the other systems. But once you bring in, for example, something in the same sentence as something else, a lot of times the results will get a lot closer. So I think this, if you were going to have a more general discussion about, what is relevancy, this would be interesting to kind of compare what you get. I think it could also highlight the effectiveness of Boolean searching. That's something I've been surprised by. As time's gone on, I've probably relied less on teaching terms and connectors just because so many of my students now, have always had Google. And I've kind of thought, they're not going to be interested in knowing about, the ands or ors or the same sentence or the same paragraph, but they actually really want to know that stuff. And they're, at least in my instance, they're really impressed by what you can do rather than just punching in keywords. So I think just kind of generally speaking, that would be one way to do it. Now, something I really am excited to try, though, is really kind of using the Ravel Judge Analytics to kind of bring like a Moneyball component to legal research examples. So we'll go through an example, but I think whether it's actually incorporating this idea when you're grading their memos or briefs, or just maybe discussing it in class or having them write up a paragraph about it. But you can actually see for particular judges, outside of their jurisdiction, what persuasive jurisdictions do they rely upon the most, or what judges do they rely upon the most. I'll give you an example here. So let's go. If we go to Thomas Thrash for the Northern District. Okay, so for the chief judge here in the Northern District of Georgia, we can see which opinions he cited the most. We can also see which outside jurisdictions he cited the most. So not surprisingly, he cited the 11th Circuit the most, then the Supreme Court. He cited the Georgia Court of Appeals quite a bit, also the Northern District of Georgia, his own district. But then he really likes to cite the 5th Circuit. And if you kind of go through, you can see, he cites the Georgia Supreme Court, he cites the U.S. Court of Appeals for the Federal Circuit, for the 7th Circuit, kind of in declining preference. We can also go in and see which particular judges he likes to cite. One feature I think that would be really neat to bring into instruction is we can look at particular motions from his opinions that he's ruled on. So if we were to select, let's go back to opinions. Let's select motion for summary judgment. So we can see that in his opinions dealing with a motion for summary judgment, he cited either CALItext, this Crest company, or Anderson, 8 to 10 times more than any other case. And if we go in CALItext, and we can actually see here, language citing, should highlight it for us. Well, I'll go back. But essentially from CALItext, it has like a really great concise statement of the standard for summary judgment. So I think that'd be interesting, if you teach students about what you can do with this analytics platform, and then say, for example, you have them write a brief on a motion for summary judgment, really evaluate what case did they use to enunciate that standard. I think I've always kind of taught it like, if you have a lot of cases that cite the same thing, maybe you look for the one that's been cited the most, or when all else is being equal, you want to use the case from the higher court. But maybe you could find a pattern with a particular judge that they really like this statement from this Court of Appeals. So I think bringing in some of that analytics could be really helpful. Also, if you go to the Opinions tab, we can look at all the opinions that Judge Thrash has written, and we could go in and see that he's written 43 opinions on employment law related issues. So I think that could be interesting to see, if you want to have the students, really look at what this particular judge, the opinions he's written on this topic before. I think that would be an interesting point of discussion. I do think this kind of brings in kind of a neat analytical kind of Moneyball perspective where you assign them a particular judge and then try and make it more, practice oriented. Okay. So this will be in the slides. Casetext, I was going to recommend that they can look up some secondary information on Casetext from the different blog postings and different practitioner insights that attorneys put on there. I think that would lead to an interesting discussion of, not all secondary sources are created equal. You really need to kind of consider source and think about, is this reliable? But I do think it also raises the issue of, it kind of depends what you're trying to accomplish. If you're looking for a real, comprehensive academic background, maybe you're going to look at a law review. But if you just kind of want some basic information, or you want to know kind of what practitioners are talking about, maybe you could find something on Casetext that would be helpful. So you can check it out. Casetext also has this WeCite program where students can go in and actually evaluate. They'll put two cases together and ask you to say, how is this later case citing this particular case? Is it referencing it? Is it endorsing it? Is it negative? So students can actually go in and do that and earn points, and through the points they can win prizes. If you guys were at Pablo's talk the other day, so if you work with Casetext, they can actually give you some examples and some exercises to have students do. But I think if you're trying to teach students about citators, this is another option for bringing this in. The last one I wanted to just show you real briefly was Lex Machina. And again, let's pick cases. And we'll do copyright, Northern District of Georgia. And we'll apply. So I think if we wanted to set up an example for where we had students say, okay, we're working with this copyright issue in this particular court, you need to advise your client, what should they expect in terms of how long it might take for the case to reach termination, what is the likelihood that it's going to go to trial versus settlement. Issues here, if we go into copyright findings, we can get a breakdown for where there was actually some sort of decision, what the reasoning was for the particular decisions. Something I think that might be neat to even do is it has law firm analytics, so you can go in and see, well, I'll just do it here. Let's do a law firm's report. And let's just pick like Troutman Sanders. Okay. Case type. Copyright. Lost my. So you can actually get it down to the level of where you look at a particular law firm's performance on a particular case in a particular type of court. So I think you might even be able to structure it as kind of like, because this is all, you know, public record, you could say, okay, well, the defendant has hired this counsel, you know, what sort of experience do they have with these cases? Of the cases they've been involved with as counsel for defendant, how likely is it going to settle? How likely is the claimant going to win? Which again, you know, these are kind of minor tweaks you could make. I mean, I don't think they completely redesign how you teach legal research, but I think it does make it more like what you would actually do in practice where in addition to needing to know what the law is, drafting your argument, you also want to kind of check out, you know, what lawyer is representing this person, you know, how often have they appeared before this judge. A lot of that kind of more practice-oriented knowledge I think we could bring in. Okay. So, you know, just my ultimate conclusion, I think by incorporating these new platforms, we can expose students to the types of tools that they'll be utilizing in practice. And again, I think it's important to emphasize types because we don't know for sure. You know, I hope Ravel and Casetext and Lex Machina make it, but we don't, you know in 5 years if they're going to be here. But, you know, make them more effective researchers and make them more practice ready and hopefully attractive to potential employers. Because I think knowing about these tools, this could be something if they can go to the partner or go to the client and really understand these analytics, it could be a real selling point. Okay. Thank you, guys. Hey, thanks so much for coming.
Really nice job.
Thank you. Thanks for coming. Thank you.
I made 2 or 3 notes to self. Do this, do this. Well, yeah, and you're always struggling with so much material, so little time. But you showed a couple of ways where you could bring them in quickly, just to provide another perspective.
That's what I'm hoping, and that it doesn't mean that you need to completely redesign how you teach cases. I mean, but it's something you can question or at least show it in class. Mm-hmm. You know, kind of minor changes, but it might give it a lot of kind of legitimacy.
One thing you might want to think about,
Yeah.
I know we need to get to John's thing.
Yeah.
But Todd and Thomas have put together something using judge analytics and Ravel Law for OCI, on-campus interviewing. You know, because you can look at a law firm, just like you suggested, and see what kind of their record is in particular type of practice group that you're interested in, see what they tend to do.
That's a great idea. Because I think it's kind of that in conjunction with Bloomberg Law. A lot of those.
Yeah.
It's like I think students are probably right at
Wow, we can find out.
Yeah.
Even down to the very person I'm interviewing.
Yeah, it's so helpful. And you talk about, I think that's the biggest fear is what if I'm going, I don't know what to talk to them about, or but
Someone's gonna wonder what's going on.
Nice job.
Well, that's what the schedule says. I could not believe it. We're almost at the 5 minutes.
Don't want to be recorded.
They don't want to be recorded.
Oh, yeah. So, since I'm interested in the web page, I know we're playing on the last minute. But, yeah. And we lost that. No, it's like.
so.
I'll see you tomorrow.
Okay, I'll see you there. Bye.
Well, I'll see you tomorrow. Right?
Yeah. Yeah, so I don't know. I don't know.
No, just thanks. What's going on? Your job's in Chicago. I know.
Yeah.
That are in law school.
And it's like, they're all. Help me, look, I can't seem to get this thing. Am I doing something wrong here? It's like really in there. Do you know?
I would squeeze these, and I'm not doing a really good job there.
I'm not missing something, right?
No, this is bizarre. Okay, I would think. Maybe it's a pull push. I don't want to break your computer.
No,
I feel like you've got to squeeze this or pull.
That's what I just knew because you'd done a couple that maybe you.
Yeah, but I don't always use this because I was using my laptop as the Slack thing,
Okay.
so I could.
Holy cow, that's really in there.
I didn't even think you could do that with HDMI.
I didn't. Well, I'll find one of the IT guys because
Okay.
I just wanted to make sure I wasn't missing something obvious there.
It looks like these are like squeezy bits, which, you know, the technical term is squeezy bits. Okay, wait, there's a thing.
Highly technical term.
There's like a thing down
I've
here.
heard that before.
I feel like, all right,
Right.
get with the IT guys. I'm done
Okay.
with this.
No, thanks for the help. I was just making sure I wasn't.
All right, I'm gonna head down to the corner.
Okay, I'll see you down there.
Most of the presentation
Yeah, thanks.
shows up
Thank you.
for, and then you guys are thinking about the